Top 10 tips to getting your marriage green card approved in 2026. Before you file your marriage green card case, I want you to understand something very important. USCIS does not approve a marriage green card case just because you are legally married. A marriage certificate proves that a marriage exists on paper. It does not prove that the marriage is real for immigration purposes. That is where many couples make mistakes. They think, we love each other, we live together, this is a real marriage, we have photos, so our case should be easy. But in 2026, marriage green card cases are being reviewed more carefully. Officers are looking for consistency, real life evidence, financial documents, immigration history, prior marriages, address history, tax records, and whether the entire case tells one clear story. My name is Remzi Kulen. I'm an immigration attorney with more than 20 years of experience helping individuals and families navigate the US immigration system. In this video, I will explain the 10 most important tips to getting your marriage green card case approved in 2026. We will cover the filing strategy that may save you months, the evidence mistakes that lead to RFEs, what officers are really looking for, how to prepare for the interview, how to avoid inconsistencies before they damage your case, and what to do after filing instead of just waiting. Let's begin. Tip number 1, the filing strategy that can save you months. One of the biggest mistakes couples make is filing only the I-130 first and then waiting months before filing the 485. The I-130 is the petition filed by the US citizen or green card holder spouse. It tells USCIS, this is my spouse and our marriage is real. 485, on the other hand, is the green card application filed by the foreign national spouse who is applying from inside the US. In many marriage cases, while filing the 485, you can also file for a Form I-765, work authorization, and Form I-131, advance parole or travel permission. And obviously the required supporting forms and documents. For many couples, especially when the petitioner is a US citizen, the beneficiary is inside the US, and the beneficiary entered lawfully, these forms may be filed together. This is called concurrent filing. Why does it matter? Because if you file only the I-130 and wait for the approval before filing the 485, you may add months to the process unnecessarily. This does not apply to every case. Some cases require a different strategy maybe, especially if there are immigration violations, unlawful entry issues, prior removal orders, criminal history, or other complications. But for eligible couples, filing the right forms together from the beginning can make a major difference. Tip number 2, your evidence should look like a life together, not a checklist. Many couples submit evidence, but the evidence does not tell a real story. I've seen that couples file some cases, then they sent 50 photos, a few screenshots, and maybe a marriage certificate. But when the officer opens the file, the evidence does not clearly show a shared life together. Your case should not look like a random checklist. It should tell the story of your relationship in chapters. Chapter 1, how you met. Chapter 2, how the relationship developed. Chapter 3 might be how you decided to get married. Chapter 4, your wedding or your ceremony and the family involvement. Chapter 5, your life together now. Strong evidence can include joint tax returns, joint bank accounts with real activity, a lease or mortgage showing both names, joint utility bills, health insurance, life insurance, or retirement beneficiary records, birth certificates of children if applicable, travel records together, photos with family and friends, messages or call records, especially for couples who spent time apart, and documents showing shared responsibility in real life. The key is not just quantity, the key is credibility. USCIS wants to see whether your marriage is real, ongoing, and supported by documents that make sense together. Tip number 3. If there is something that is going to confuse the officer, make sure you explain it while filing the case. For example, if you have a criminal conviction, if you had an arrest before, if you had a non-immigrant visa status violation, please put it on the forms. The forms have an addendum section where you can explain all of this. And if that space is not sufficient, you can always write a letter to the officer. It is important that you explain any inconsistencies or anything that can get in the way of the officer approving the case beforehand, so that the officer has an idea about it and he can address these questions with you. Because when filing a case, you have the opportunity to organize the case and guide the officer through the evidence. So if you had some kind of a status violation or a criminal case, or you had an arrest, make sure you explain all of this in the application. Do not think that just because it's a small thing, USCIS will not realize it. It is important that you disclose everything at the outset. Tip number 4, social media can help you or hurt you. Many couples do not realize that their public online presence can become part of the overall picture. Your social media does not need to be perfect. You do not need to post your relationship every day, but your public information should not contradict your immigration case. For example, if your forms say you live together, but your public posts suggest you live in different states, that can raise questions. If your relationship timeline says you started dating on one date, but your public posts suggest a different timeline, that can create confusion. If one spouse appears publicly as single or in another relationship, that can become a problem. Social media should never be manufactured or fake. Do not create posts just to impress USCIS. But you should be aware that public information can either support or undermine the credibility of your case. The goal is simple. Your online presence, your forms, your documents, and your interview answers should all tell the same story. Tip number 5. The medical exam can delay or damage your filing. Form I-693, the immigration medical exam, is one of the most common sources of delay. This form must be completed by a USCIS designated civil surgeon. Do not go to just any doctor. It has to be a USCIS approved doctor. USCIS has a civil surgeon locator, and you must use an authorized civil surgeon. You should bring your vaccination records, childhood vaccine documents, school vaccine records, prior medical records, and any available proof of required vaccinations to your medical exam. If the medical is missing, incomplete, not properly sealed, or not submitted correctly, your case may be delayed or rejected depending on the filing requirements at the time. This is not a small technical issue. A missing or defective medical exam can add months to the process. So before filing, make sure the I-693 is properly completed, signed, sealed, and included in your application. If there's a problem with the medical, the only person who's gonna know this and realize this is the officer who's gonna open that medical and tell you what's missing. If there's something missing, you can always send it to the officer later. Tip number 6, the income requirement is not just a number. In all marriage green card cases, the petitioning spouse must submit Form 864, Affidavit of Support. This is a serious document, and it's a legal contractual relationship between the government and the person who's filing it. The sponsor is telling the US government, I have enough income or assets to financially support this intending immigrant. For most sponsors, the net income must meet at least 125% of the federal poverty guidelines. For 2026, for a household size of 2 in most states, that number is $27,050. But here's the trap. Meeting the minimum number does not always mean the case is strong. If the sponsor barely meets the guideline, recently changed jobs, has inconsistent income, files taxes irregularly, receives income in cash, or has a complicated household size, USCIS may look more closely. If the petitioner does not meet the income requirement, a joint sponsor may be needed. A joint sponsor is a US citizen or a green card holder living in the US. A joint sponsor must also submit Form 864 and provide proof of income, tax records, status, and eligibility. Do not treat the 864 as a simple form. Financial sponsorship problems are one of the most common reasons marriage green card cases receive an RFE, and I have to tell you, 864 is not an easy form to fill out. Tip number 7, prepare for the interview like it could become a Stokes interview. Most marriage interviews are not Stokes interviews. A Stokes style interview is when the spouses are separated and asked detailed questions to compare their answers. Traditionally, this happens when USCIS sees red flags, but couples should still prepare seriously. You should be ready to answer questions about how you met, when the relationship became serious, the proposal, the wedding, daily routines, where you live, who pays which bills, each other's families, prior marriages, divorce dates, children, travel history, important dates, and your spouse's work schedule and habits. Don't forget, the goal is not to memorize fake answers. The goal is to review your file together so that both spouses are comfortable, consistent, and calm. I call this romantic homework. Each couple preparing for this exam should get together, spend a few hours on their relationship history, and make sure they talk about everything consistently. A real marriage can still look suspicious if the couple is nervous, unprepared, or inconsistent about basic facts. Preparation matters. And this is what I hear from some of the couples. If a relationship is real, if a marriage is real, of course there will be things that we don't remember. Of course there are things that we're not going to be consistent about. But don't forget, that's not how USCIS looks at it. USCIS officers like it and love it when couples come to those interviews prepared. Their documents are in order, their stories are in order, and they don't have to patch the story themselves. So do yourselves a favor and get prepared for your interview. Tip number 8, do not let small inconsistencies become big problems. One of the most damaging mistakes in a marriage green card case is inconsistency. USCIS may compare information across multiple forms, prior immigration filings, address history, entry records, tax documents, public records, and information already in the government system. Before filing, check every detail. Full legal names, dates of birth, marriage date, divorce dates, addresses, employment history, entry date, I-94 information, passport information, prior immigration filings, criminal history answers, and prior visa applications. Do not leave required fields blank. If something does not apply, write not applicable or NA where appropriate. If an answer requires explanation, explain it clearly. The form has an addendum section. A small mistake may look harmless to you, but to an officer, it can look like a credibility issue. Your case should be accurate, consistent, and complete before USCIS ever opens the file. Tip number 9, if you receive an RFE, do not panic and do not rush. An RFE means request for evidence. It does not always mean your case will be denied. But it does mean that the officer is not ready to approve the case based on what was submitted. Many people make the mistake of rushing the response as if giving a quick response will get the case approved. They quickly upload random documents without carefully reading what USCIS is asking for. If you receive an RFE, read it line by line, identify every concern, make a list of each document requested, gather evidence that directly answers each issue, prepare a clear cover letter, use numbered exhibits, organize the response so the officer can easily follow it. Do not send a messy pile of documents and hope USCIS understands. An RFE response is your opportunity to fix the problem. Use it carefully. Don't rush. Don't panic. Tip number 10. Use the quiet period to build more evidence. After filing, many couples complete biometrics and then see the same message for months in their system. Case is being actively reviewed. This is what we call the quiet period. Do not waste this time. Continue building your marital evidence. Save monthly bank statements. Keep lease renewals. Save joint bills. Keep insurance updates. Take normal photos with family and friends. Document travel together. Keep proof of shared financial responsibilities. Save important mail showing both spouses at the same address. If an interview is scheduled later, you will not be scrambling. You will already have updated evidence ready. Marriage green card cases are not frozen on the day you file. Your life continues and your evidence should continue too. I'm gonna throw in a bonus tip. When you go to an interview for a marriage case, the interview is a chance for you to update your information and fix if there are any errors in the application. It is possible that your addresses have changed, you've changed jobs, or while preparing for the interview, you realize that you entered some information wrong on the forms. Interview is the best and probably the last chance for you to update your records and your information. If you did something wrong, if you checked the box wrong, if you entered some information wrong, tell the officer, I think I did this wrong, I want to fix it right now. That's the best opportunity to fix any mistakes. And don't be afraid of fixing any mistakes, because that's when you have the opportunity to talk to the officer who's going to decide on your case. So a marriage green card case is not just about being legally married. It is about proving that your marriage is real, that the foreign national spouse is eligible, that the financial sponsorship is sufficient, and that the entire case is consistent from beginning to end. In 2026, the strongest cases are the ones that are prepared carefully before USCIS ever opens the file. If you're planning to file a marriage green card case, or if your case is already pending and you are worried about evidence, income, interview preparation, or an RFE, speak with an experienced immigration attorney before making a mistake that could delay or damage your case. If you enjoyed this video, please like, subscribe, and share it with someone who may be preparing for a marriage green card case. If you have any general questions, please put in the comments section and I will try to respond to them. If you need help with a specific case or specific questions, contact Kulen Law Firm to schedule a consultation. See you in the next video.